Record video. So all right, so since the passage of AB 1482 in 2019, which took effect January 1st, 2020, there have been significant changes to how a landlord can evict in California. Now, if your property is subject to AB 1482 and the tenants have resided there for longer than the minimum statutory period, then the tenant is entitled to at-fault protections. In other words, it's going to be just cause, at fault, or no fault, just cause, one or the other. In other words, if the tenant has done something wrong, then you can evict them basically the same as before. But if the tenant has done nothing wrong, then that's called no fault, just cause. Either way, you have to provide the reason for the eviction. But if it's a no fault, just cause, then there are protections that the tenant is subject to, and you can only evict them under certain limited circumstances. It's no longer carte blanche that you want them out so you can evict them because you just want to raise rent or you just don't like them, whatever it is. If they are committing a waste, they're not paying rent, they're committing some kind of breach of the covenant that they signed, in other words, breach of the lease, rental agreement, then you still can evict them, and it depends on the nature of the eviction. If it's a horrific violation, you can give them 3-day notice to cure or quit, or even just a 3-day notice to quit, depending on the type of violation. These are quick overview points. So don't use this as legal advice to your specific case. Hire an attorney, hire me, hire somebody who's competent in this, who can analyze the specific facts of your case to the specific laws that are relevant in your jurisdiction. So after AB 1482 passed, there were rent caps. And if your property is subject to AB 1482, then you cannot increase the rent more than 10% ever. But it's usually less than that because it's based on the Consumer Price Index and 5%. So here's how it works. 5% is the baseline, and then you can add the increase to inflation, which is based on Bureau of Labor Statistics, depends on where your property is located. But you take the 5% base rate, and then you add whatever it is, 3.8%, the CPI adjustment, and then it's 8.8%. That means your rent cannot increase more than 8.8% per 12 months. So a lot of landlords are unfortunately going right up to the maximum because they don't know if there's going to be another state of emergency and anti-price gouging law, which also takes effect. So what we have now is a decreasing number of properties in California that are exempt from rent control. Like Costa-Hawkins was a step in the right direction if you're a landlord to keep properties exempt from rent control. But what AB 1482 did was chip away at those exemptions. And then in addition to that, you have the anti-price gouging statute that takes effect whenever there's a state of emergency in California, which can go on for longer than a year, and it doesn't matter that you have a break in the tenancy, it really restricts the landlord's ability to raise the rent. And if the landlord violates that, it's a penal code violation. So AB 1482 is the main point of this video, and you have to determine whether your property is subject to AB 1482, and if it's not, because let's say it's a single family home, it's a duplex, it's a home that is not owned by a corporation, if it's owned by an LLC, none of the members are corporations, it's not owned by a REIT, then you're probably exempt from AB 1482, but you have to take an additional step, which many small individual landlords for single family homes don't avail themselves of. You have to provide the tenant a notice of AB 1482 exemption. Now it's presumed that any lease that starts now is either subject to AB 1482 or exempt from AB 1482 as long as it has the requisite exemption form. All right, so any lease now is probably not carried over from a few years ago, 2019 or earlier, when that existing leases would have been excluded so long as they met the certain criteria. Let's not talk about that because that's going to confuse you. But the main point is, if your property is exempt from AB 1482 and you know this, you've gone through the checklist, then make sure your tenant receives that notice of AB 1482 exemption. If you don't, then you're going to be subject to AB 1482, which is going to be what I'm talking about the rest of this video for the next few minutes. So AB 1482, if it applies, that means you have to provide a certain level of protection if your tenants move out. Now, if they are moving out because it's no fault of them, it's no fault just cause because you are availing yourself of one of those exemptions I know it gets confusing, right? Let me just try to simplify this more. If you want your tenants out, but they've done nothing wrong, that's called no fault just cause eviction, and therefore you have to provide them relocation assistance. There's other protections that they get as well, but that's if they're a property that's subject to AB 1482. So if they have done something wrong, then it is easier, as long as you specifically clarify on the eviction notice that they've done something wrong, here's why they're being evicted, and then depending on how long they've been there, it's going to be a 30-day notice to vacate, or it could even be a 3-day notice. But in general, 60-day notices to vacate are very rare now. Not impossible, but rare. So with a 60-day notice in the past, if the tenant had resided in the property for 1 year or longer, not less, less than a year, 30 days. 1 year or longer, 60 days. Then you can give them a 60-day notice that you're not going to renew the lease, that they have to move out. Nowadays, even if you just don't want to renew the lease, you still have to give them notice of that, and you have to have good cause not to renew the lease. It's a big difference. This is why landlords are getting tripped up, sometimes in trouble. So if you don't want to renew the lease, or you just want them out, you have to find a reason to get them out. And if you have a good reason, then you can use usually a 3-day notice. Now, the 60-day notice is probably not going to be applicable if they're under an AB 1482 covered property. And here's why. Because if they've done nothing wrong, then you can't just serve them the 60-day notice. But if you are moving your family in, you're taking the house off the market, you're complying with a government or administrative agency order to perform repairs to the property, then those are certain ways around the law that allows you to use a 60-day notice to get them out. But it's not as common as it used to be. So you need to be sure that if they are subject to AB 1482, then you are giving them the proper notice. This is an overview, all right? It depends on why you're evicting them. There's numerous other considerations. How long the tenant's been there. Excuse me. Sorry. And if the tenant has been there for a year or longer, additional protections apply. So if the property is subject to AB 1482, the tenant's been there for less than a year, unless there's other tenants there who have been there longer, that individual tenant is not automatically subject to the just cause protections unless they've been there for a year or longer. And it gets a little more complicated. If there's another tenant that's been there for 2 years or longer, then it's presumed that all of the tenants now are subject to those at fault or no fault just cause protections under AB 1482. So in summary, don't just use a 60-day notice to get somebody out if they haven't done anything wrong if they're subject to AB 1482. Make sure that you've done the analysis and that if they've done something wrong, then it's not a 60-day notice. It's probably a 3-day notice to cure or quit. And if it's an incurable violation, it's probably a 3-day notice to quit. All right, so there's more to talk about when it comes to not just AB 1482, but notices from before the lease begins, when the lease begins, during the lease, and when the lease is about to conclude. There's specific different notices that you have to keep updated and serve your tenant in a timely manner in a way that is procedurally compliant when it comes to service. My name is Nick Komeyer. If you found this helpful, let me know and I will make more. Thank you.